To your landowner, who owns the water on your land? In the state of Texas, the state owns all the surface water in trust for the public. Now, this is governed by the Texas Water Code. If you want to use that water, you will likely have to have a permit. To use surface water for purposes like irrigation and industrial purposes, you need to get a permit from the Texas Commission on Environmental Quality, or TCEQ. But there are some exceptions where no permit is needed. So, for example, if you need the water for domestic and livestock use from streams that border your property, then there's an exception. If small scale use, like for ponds and fishing in your farm or ranch land. Now, groundwater is generally owned by the landowner. What's groundwater? It's the water found beneath the surface of the earth, like in aquifers and wells. Under Texas law, groundwater is considered the private property of the landowner. This is an old law going back to 1904, and we call it the rule of capture. This means that a landowner can pump and use the groundwater beneath their land without a permit, even if it affects neighboring wells, with some exceptions. North Carolina has very similar rules. This is why we see so many breweries going into North Carolina and pumping out so much beer, is because they're able to pump into that well of water and distill other spirits as well. In Texas, water can be used for commercial purposes, but it can be tricky due to all the rules and the laws that involve the water code. So my recommendation is to contact a real estate attorney that knows the water laws affecting your land.